Hello friends, how are you? Namaskaram. Today I am going to discuss an important topic concerning quashing proceedings, specifically in context of various acts, whether it may be of prevention of corruption, dowry harassment, any law in force for the time being under which you are wrongly prosecuted. So basically quashing is the extraordinary remedy which is given to Honorable High Court so that they could quash the proceeding if they find that the concerned proceeding is abuse of process of law by the bare perusal of the evidences available on the record. You got the point now? So whenever a FIR has been lodged against us, we got confused whether to move for quashing or not, or whether we should move for anticipatory or not. So these points are not easier to be answered, as you know that. For example, if I am giving you a consultation on a specific point, you may either follow me or not. And subsequently, if you engage another consultant for more appropriate consultation in that scenario, he may suggest you some different remedy. So all this consultation inter alia might cause zigzag in your mind. So what is correct or what is wrong cannot be decided even by me, even by that consultant, even by you, until and unless we all are clear on a common issue that is called concept. There are various judgments by various High Court. Some of them suggest that the quashing should be done immediately. Some of them suggest that the quashing should not be done immediately if the controversy is on the record. And even the said position has been settled by Honorable Supreme Court in Caton of Judgment. But settled legal position is that the proceeding should be quashed if the said proceeding is the abuse of process of law. So first we have to identify the primary condition for exercise of right of the Honorable Court as per section 482 of CrPC, that the entire proceeding is abuse of process of law until and unless we are able to do the same. In that scenario, we could not be succeeded in the quash case. For example, if a case has been registered against you, what you will do? You will do nothing. You will simply go to advocate, and he will suggest you to move for anticipatory bail, or you may move for trial proceeding as well. Or he might suggest you for the quashing, but things still are unanswered. What is the basic concept of abuse of process of law? And we have to understand the same so that we could easily move for the quashing and could easily understand the concept behind the same. Okay, now you got the point now? So first you have to note in your notebook the principle of quashing. There is no straitjacket formula regarding quashing. It depends upon facts and circumstances. For example, if the concerned complainant is bringing a case which is totally vague, baseless, and without any supporting evidence, in that scenario, the case would not result into conviction. And the court could easily exercise the power of quashing and to set aside the alleged proceedings. Second, and if it is appearing that there is a strong motive behind the said complaint, means it is motivated and lodged with intention to extort money. In that scenario, it could be a good case to move for quashing. So, before moving further, we have to remember that the point of corroboration is also recognized by Honorable Bombay High Court in its recent judgment, wherein it has been specified that if the things are uncorroborated, the chain or linking evidences are missing, in that scenario, it might be a good case for the quashing. So we must remember and must keep in our mind the said principles before moving further. Got the point now? Easy? Got the point? Should I proceed further? Okay. In the case at hand, the matter has been adjudicated by Honorable Gujarat High Court. In case of Kalpesh versus State of Gujarat, the case has been adjudicated on 28th of August 2024. But this is not a case where certain things are adjudicated. But this case for the first time giving us the practical example whether we should move for quashing or not. In this case at hand, the concerned accused had been prosecuted under section 120B, section 505 of IPC with section 54 of Disaster Management Act with section 3 Police Incitement to Disaffection Act 1922. And apart from that, there are multiple FIR against the concerned accused. But despite of having any fear, he planned to move for the quashing. Yes, you rightly heard, which I submitted, he planned to move for quashing. Friends, when we are doing travel planning, when we are doing family planning, then why we are not doing the case planning? The planning is necessary because in the planning we could easily identify what are the loopholes in the case of prosecution, whether it will stand on the floor or not. If the allegations are general vague, in that scenario we could easily move for the question. So the first task is that we have to ascertain the allegations are general, vague or cannot stand or resulted in conviction of the concerned accused. In the present case at hand, the concerned complainant had lodged the FIR and submitted the matter to the concerned police, in which he has submitted that the concerned accused persons are culprit. They has the conspiracy, inter alia made a group, and apart from that, the inter alia added concerned complainant as a member on 18th of July 2020 without his consent and knowledge. The said fact had come into the kind knowledge of the concerned complainant on 22nd of July 2020. So that is a basic fact. And as far as the motive is concerned, he submitted that the concerned group is made just to do thuggy with the concerned police constable, and apart from that, it is made to instigate them to create disaffection against the government, and apart from that, in a tough corona time, just to spread the disease and just to provide the uncontrolled situations. The illegal activities has been done in the said group so that the entire country may be endangered. Okay, now these are the basic points that resulted in the FIR by the concerned police. Okay, now after FIR, the concerned accused had submitted the representation, and inter alia he moved before the Honorable High Court for question. He submitted that this is the extraordinary case where the court should exercise the power to prevent the abuse of process of law. He submitted that a thing become a crime when there is actus reus or mens rea. When there is no such element on the record or either of the element is existing in that scenario, the accused could not be robbed in the routine manner. You got the point now? Actus reus and mens rea are two important points for the implication of the concerned accused in the crime. So he submitted that basically there was a protest of teacher in the state of Gujarat, and all of them inter alia submitted to the concerned government regarding the pay scale of rupees 4,200. Inter alia their demands were not considered, and later on in consequence of the protest they were considered and inter alia benefit was given to them. In the similar fashion, government promised to the concerned police officers that the grade pay benefit of rupees 2,800 would be given to the concerned police constables, but despite of that no benefit was given to them. They made the representation, but it was not considered by the concerned administration. And apart from that, number of MLA, even MP intervened in the matter. They submitted to the government to provide the facilities, the services, and apart from that, they also emphasized on the grade pay of rupees 2,800. But despite of that, it is not provided, and also the matter has been telecasted or broadcasted on television appropriately. And that's why, to make aware the concerned police constables about their rights and the manner in which they could put up their rights in due course, a telegram group was made, and by the virtue of link, multiple police constables had joined the group, and apart from that, it was basically a learning group in which data material has been shared to aware them about their rights, about the promises claimed by the concerned government to be provided to them, but still the same were not provided. And later on, DG directed to remove the group by passing the circular, and inter alia the group was deleted. And all these facts are uncontroverted. That is the emphasizing point on the part of the concerned defense. And apart from that, the group name is 2,800 Police SRPF, which suggests that the entire fight was lawful in the legal manner. And apart from that, all of them were insisting that the grade pay benefit should be given or availed to the concerned police constable. So the things are in the peaceful manner. There is no malified intention, and apart from that, there is nothing on the record to suggest that any crime has been committed. Okay, now, so crime means anything in violation of law. So where is violation? There is nothing on the record. And as far as the offence of criminal intimidation is concerned, there should be the statement by the accused which resulted in the public alarm or disturbance of tranquility. No such scenario had been occurred. So when there is nothing on the record regarding the same, in that scenario, prosecuting the accused in the routine manner without any basis would be abuse of process of law. As far as section 3 of police incitement to disaffection it is concerned, disaffection should be against the government. And apart from that, the object of such disaffection is to induce the police so that they could withhold themselves from doing the services, and apart from that, the same resulted in breach of discipline, but no such scenario has been occasioned. Inter alia, the attention of the court has been drawn towards two important judgments. One is of Kedarnath Singh and other is of N. Sangodam versus State of Tamil Nadu. In both judgments, it has been specified that the breach of public peace is sine qua non for the prosecution of the concerned accused if there is a peaceful agitation on the issues. In that scenario, the accused could not be prosecuted in the routine manner, and apart from that, if the concerned MLA, concerned MP is going to submit the letter to the concerned government regarding the rights of the concerned person and later on they are prosecuted, such prosecution is unjustified, because whatever we are going to do is justified by law as per Article 19, Subclause 1, Subclause A of Constitution of India, which gives us the right to have the proper speech and expression. And apart from that, Section 54 of Disaster Management Act comes into motion when the rumors are purged with intention to outrage the disaster, means the disease, and to create the panic situation, but for which the procedure is to file the complaint as per the protocol. So, by this judgment we could draw, which are very much helpful to us to understand the basic concept of the quashing. Number one, whenever FIR is lodged, do not be panic. Remember my words, do not be panic. Just read the entire FIR and apply theory of filter. Means segregate the true fact from the false fact. Number two, after segregation, we have to emphasize up to what manner the facts are false. And if we are having any facts that are uncontroverted, we could submit the same before the concerned court. Number three, we are required to make the proper briefing of the facts which are uncontroverted so that we could submit the proper draft before the competent court, and apart from that we are required to do the research work. That is point number 4, so that we could support our substance with supporting law. Okay now? And number 5th, we are required to do the proper briefing before proceeding further, which I suggested you. The primary step is to make the draft more effective, in which you are required to emphasize on the facts. Number 2, in which manner the story is false. Number 3, what is your stand. And number 4, how you could stand your case with the help of uncontroverted facts. There should not be any controversy. Number 6, we must remember the judgment of Honorable Supreme Court passed in the way back of year 2011, in which it has been specified that if the things are uncontroverted, they could be considered. Okay now? And point number 7, while arguing the case, you may argue the case at your own level, which is permissible as per section 32 of the Advocate Act. And point number 8 is that whenever you are going to argue or your advocate is going to argue, just make the proper synopsis, and we have to do the attack on the clinching point that is causing trouble or that is causing the criminal law to be in motion against you. And point number 9, you have to specify the court that this is an extraordinary case wherein the power is required to be exercised. If it is not exercised, then serious perjury will be caused. And point number 10, we have to emphasize on the point abuse of process. So we have to do the drafting in such a manner so that we could chalk out a case for abuse of process. And if we are not able to do the same, in that scenario, serious perjury might be caused to us. Okay now? So this is the important perspective of law we must remember and must bond in the mind while contesting the case for, say, for what? For quashing. Yes, you rightly got the point. So do not be afraid. Just fight for your rights, but in systematic manner so that we could win and could settle the grounds. So see you in the next video. Till then, Jai Hind, Jai Bharatam.